the report back to the Constitutional Review Committee for further consideration and report by the 4th of December. Somehow this motion was not pursued. However, it does in our submission indicate that the applicant is not alone in its view that the report is flawed and needs to be referred back. By virtue of the content of the answering affidavit, the first respondent has further made significant concessions, so much so that the applicant challenged the first respondent to agree to the referral of the matter back to agree to Part B relief so that this matter could be resolved within a very short time frame. In other words, the challenge was to essentially do what the ANC had requested, had tabled in Parliament. Now, there's no response to that.
We've no idea, unless you know, the reasons why the ANC deferred the matter back.
The only matter which is before court is the fact that there was such a motion. We don't have the reasons, that is true. But it is a motion introduced through the Chief Whip of the ANC. Now, these proceedings, my lords, are about meaning participation by the public in the workings of the Constitutional Review Committee.
Maybe before you go there, I think follow up on what Senior said. What does the referral, what is the impact of the referral of the decision back by the ANC, which, as you say, was never followed up? What is the impact thereof on the proceedings?
It would make Part B proceedings academic, and what remains is costs.
Okay.
And that would not be urgent.
So it would appear that there is a referral of the report back to the committee.
But there was a motion which was not put, that was tabled, but somehow did not proceed. All that we are saying is that very fact indicates that where the applicant seeks to impugn the decision adopting that report and asks for it to be referred back, it does so in good company.
In other words, that report has not been acted upon.
No. No. It has not. That matter, the referral of the report is ostensibly, the matter is to serve before Parliament on the 4th of December, which informs the urgency of these proceedings. It would have been the 27th, it moved out to the 4th. And for that reason, the need to approach the court on an urgent basis remains, regardless of the short extension of the date on which it is to be considered by the National Assembly.
Where is the report now?
Well, the report is Annexure A before this court.
Meaning in the process, where is it? Is it being acted upon? Is it being referred for reconsideration? What is the status of the report at this stage?
That report, as we understand it, was adopted with a view to it being placed before Parliament on the 4th of December for adoption. So it is a report that would serve before Parliament on the 4th of December. And our submission is that Parliament preempted that by saying, well, it should go back first for reconsideration, but that decision was never taken. But it does indicate a concern, and our submission is procedural concerns about the report and its rationality, the adoption of the report and its rationality. Sorry, Madam.
Let's just get clarity. You say the report was referred back by one of the political parties.
No. There was a
motion.
There was a motion, it wasn't voted on.
So if it wasn't before Parliament, how could it be referred back?
Well, my Lord, I think the point is that it wasn't referred back because the motion wasn't voted on. But the fact that even the ANC wanted it referred back is apparent from that very motion, and that if they had acted upon it and had done it, we would not have been here, because the matter would have been referred back because of the flaws in the report. That was not done.
Because of flaws in the report, neither you nor this court know what the reason is for the ANC's motion.
Yes.
So how do you submit it was because of flaws?
My Lord, if it was submitted back for reconsideration and report, it meant it wasn't acceptable in its terms
To who?
to the majority party.
On what basis?
Yeah. My Lords, could I, with respect to avoid a delay in court time on this issue, say that our only reference to that motion is the fact that it is a matter of public record. It took place last Thursday and indicates that the ANC wanted to table a motion, didn't proceed with it, but the effect would have been that it would be referred back as we are seeking in Part B in these proceedings. Not today, but if the relevance of this, my Lord, is that we challenge the respondents to agree to it being referred back so that we do not have this undue delay of which the applicant is being accused as being its primary objective. That being said, my Lord, we are here on the merits of our application now, and would like to proceed to address the application. Yes.
Very good company.
Yes.
We needed to understand
Yes.
what exactly it meant. You were saying.
Yes, that is
What basis you still rely on the motion? It's totally unclear. And so for all intents and purposes, no more than that. And you're right. Let's proceed with that.
the fact that such a motion we indicated would have had it been passed or had our learned friends agreed to the referral back. This would have served for Parliament on the floor to bring it back in any event. The question is we are, with respect, seeking a time.
Where the report is in the process.
Yes.
You say on the 4th. The purpose of putting that report on the agenda of the 4th is for the purpose of referring back. What is the purpose?
No, my Lord, as we understand it, because the decision on the 22nd was not put to the vote, that decision, had it been taken, would itself have referred the matter back to the Constitutional Review Committee, and they would have been asked to report back to Parliament by the 4th. But because that motion wasn't passed, as we understand it now, this very report and its adoption will now serve before Parliament on the 4th for acceptance.
Not for referring.
Not for referral.
Not for referral back
And we
to
are seeking court intervention to secure the rights of public participation in the process before that takes place.
So in other words, there is no intervening referral in the way of this report
What
towards adoption.
the adoption by Parliament that was scheduled for the 27th of
Has
this
been
report has
postponed.
been postponed for adoption on the 4th. That's the position, because that motion I've spoken of was not put to the vote.
So you can understand this. On the 27th, there will be an adoption of the Parliament.
That it would be placed before Parliament.
Be on this Parliament.
Those are the that moved up to the 4th.
So there was a Parliament as an agenda.
Yes.
This report would have featured on the agenda for the 27th
Yes.
to be considered and adopted.
Yes. Yes.
It's already before Parliament, to the extent that it forms part of the agenda, or had formed part of its agenda. On that basis, it would appear that a political party then had a motion to refer it back to the committee.
Yes.
Now, if it's already before Parliament, it's probably on the agenda already for December.
Yes.
So already all the paper would wherever it might be in Parliament for the 4th.
We understand that, yes.
No relief is being sought. No relief is sought against Parliament.
My Lord, with respect, as far as the relief is concerned, your Lordship will see that Part A is aimed at a suspension and precluding the committee from moving the report before Parliament. The notice of motion in Part A, in prayer 2, seeks the suspension of the decision adopting the report, and prayer 3 seeks an order restraining the committee from submitting that report to Parliament until Part B has been finalised. So it's scheduled, but moving the report on the day for purposes of acceptance, that is subject to what we sought in Part A.
Let's read 3 again. 3 says an order of restraint to submit. It will therefore appear that it's already been submitted to Parliament, and therefore it appears on its agenda, or had appeared on its agenda for the 27th.
My Lord, it's on the agenda,
Yes.
but for it to be submitted, someone needs to rise and move it, and we submit that that has not taken place. The relief that we seek here is to set the process in order as far as public participation is concerned before Parliament decides on it.
Mr. Abishwakli, then you would be seeking to interdict a process in Parliament.
No, with respect, the first respondent is the relief is seeking to restrain it from submitting it to Parliament for approval.
No, it's on the order. It's on the agenda. It was on the agenda for the 27th.
Yes.
For some reason, it was not dealt with on the 27th.
Yes.
It's now for the 4th.
Yes.
So it's already on the agenda for the 4th.
Yes.
It's on Parliament's program for the 4th.
Yes.
So any restraint would have to be against Parliament from dealing with its agenda. No relief is being sought against the Speaker of Parliament or the chairperson of the NCOP to deal with the agenda.
My Lords, with respect, if we look at prayer 3, if the Speaker of both the National Assembly and the Chairman of the NCOP are respondents,
Yes.
and the relief aimed at prayer 3 is a restraint restraining first respondent from handing annexure aid to second respondent. So the relief does have impact on the National Assembly.
It's already on the agenda. So what you're seeking to do is, it would appear that it's already been sent to Parliament. It's been placed on an agenda, and the process in Parliament would be that someone from the committee rises to motivate the report. It's very different from submission. It's already been submitted.
My Lord, with respect,
So if you want to stop Parliament from dealing with its business, then there should be an order restraining Parliament from dealing with its agenda.
with respect, my Lord, we are seeking an order against the first respondent who is one of the parties that can submit a report to the National Assembly under the Constitution, and the second respondent, being the National Assembly, is the other side of the coin. Now, my Lord, we have both parties before court, and it's about the submission for approval of that very report. With respect, my Lord, there's nothing wrong with it.
No. You were saying that your relief in prayer 3 is not as clear as you were supposed to submit.
Well, Lord,
Is that the Speaker, no relief is sought against the Speaker, who will deal with his or her agenda on the 4th. Because the submission of the report has already been sent to Parliament in order for it to be placed onto the agenda.
yes.
And I would imagine, in good practice, parliamentarians would have received copies of the agenda, any documents that is to be considered. So it's already before members. Does that point out the practicalities contemplated in 3. But I'm not sure how far we can take it now. We hear the other side later on.
That is so,
But you've heard our concerns about
that is so, my lord. If the substance of paragraph 3 of the relief, my lord, is that a restraining order is sought against the Constitutional Review Committee from submitting that report to the National Assembly and the National Council of Provinces until Part B has been finalised. Now, it is not before Parliament other than something which is on an agenda, but it is with respect something on which someone needs to rise, and that is the issue that is affected in substance by Prayer 3. It has the same effect as telling Parliament not to consider it.
is not being restrained. The Speaker is not being restrained from calling the chairpersons of the first responder to rise and to formally motivate the report or place it before. That's the issue we're raising.
Well, my lord,
And that's the difficulty of your relief Prayer 3.
my lord, if they are restrained, they cannot rise even if requested to do so. The impact is the same.
Yes,
But we have already established that it is submitted, isn't it?
Not submitted. It is
What is
merely
it?
on a list of matters to be discussed. It's on an agenda.
So in
But
other
as
words,
a formal referral as such, that is not really the issue. That is what is being sought to be prevented by Prayer 3.
are you not referring to preventing debating issue?
No, with respect, an actual referral to Parliament for consideration of the report, because we submit that it is an illegality.
We're not dealing with whether there's a illegality at this point. It's about whether it's already before Parliament that we are concerned.
Lord, all that I can
And I think
say,
we can never be able to emphasize what we're so concerned about because of the relief 3. If it is already before Parliament, then as my brother has said, the process will have been, or if to see, or to see was to prevent that report being created. And therefore,
Lord, with respect, we would be walking straight into a trap, and we would not be doing that. Because we would then be seeking interdict based on Parliament, which is an issue that would go straight to the Constitutional Court. So the suggestion that the relief is not competent with respect to something that we make competent, in fact, we say that the substance of what is exactly that a party, which is the Constitutional Review Committee, will be interdicted from acting what we say unlawfully.
Mr. Bashar, the trap that you talk about, is that you would have had to see an order from Parliament for anything on the agenda. B, calling on the chairpersons to motivate or any person to motivate. Now, that you could effectively what you're attempting to do is asking for the relief that gets you into the but that is effectively is to stop Parliament from carrying out business on the phone. And you correctly concede. That's in fact
you will have to go to the
My Lords, with respect, the relief we seek is precluding the first respondent from handing the document to the second respondent. We are not challenging the conduct of the second respondent and the Constitutional Court's exclusive jurisdiction does not arise. With the legislative process, which on these papers it is common cause, is a ring-fenced, separate process prior to initiating the process of legislation. That means it's within the ambit of this court, and we're seeking relief that this court can grant. The suggestion that we should change it would take this court's jurisdiction away.
But you see, indicated that you asked for the trial to be expired. And if you wish to do that, you cannot be before us.
My Lords, all that we have as a participation in the public participation process is an indication that the which is claims of
On the 15th of November, the report they could have said, speak.
respect to is related to service on Parliament, we would like correspondence. There's no court consent to and it's not an issue that was raised or taken up by the papers. So for that reason, Parliament was told about served by emails, etc. So for that reason, my Lord, with respect, had we been told the report forms part of our suggestion is that leave this so yeah. So should the Speaker on the 4th say, every member has a copy of the report, it's part of what the as a we put
Yeah.
ensure without advance this as the foundation, the characterization of matter, and that is that the Constitution demands to be provided and in subparagraph 2 it is required of this committee first May resolutions on the constitutional matter. Law, which delegation, concerning by the response that it became apparent lacking. Now that point, really that this committee has powers of assessment and party service provider. All the public information abandon in our head, but for purposes of the as far as the agency is concerned, we have the basis of why they know that this is the power of analysis rule, and that its report was about that.
Mr. Smith in July makes an announcement,
Yes.
but we know in June, it's part of your elections.
Yes, my lord.
In June, Mr. Mathopa makes a public announcement
Yes.
of the appointment of a service provider. In July is the second announcement by Mr. Smith. That's the chronology.
Yes, as far as the service provider is concerned.
Yes, the knowledge, and the first time the public gets to hear of the appointment of a service provider. June 2018,
Yes.
and then again in July 2018.
Yes. My lord, you do understand that we're not attacking the power that is entrusted to the committee to that service provider. That is the basis for our approach.
So I just get that clear. You're
Yes.
not attacking the appointment of the service provider.
Well, my lord, can I qualify that? The mere fact that a service provider is being appointed is not the analysis.
In particular, the analysis, which you refer to as an unlawful delegation.
Yes.
But the appointment can be accepted by the sentence. There is no attack on the lawfulness of the appointment.
I do have to make clear. The mere fact that a service provider provider is being given power to analyze, then the appointment itself needs to be is brought into play. But that decision, we don't know who took it, but we do know that the committee cannot delegate its assessment power to such a committee, so we are dealing with the decision of the committee. Our learned friends are suggesting that we are attacking the wrong decision. Well, Lords, we don't know whose decision it was, but we do know that the committee cannot delegate its power of analysis. And that the fact that it adopted a report saying that the assessment was done by a third-party service provider only became apparent on the 15th of November. So if I say that the decision of appointing the service provider, that issue it arises, we are saying that we accept in general a committee would need clerical assistance. That's not the problem. But you cannot delegate your power of analysis, and that only became apparent very recently, and for that reason we are here before this court. As far as the second point is concerned, this is an impermissible interference in a legislative process. My Lords, I will take it. Yes. Sure.
This analysis, what is that in attack? The analysis we do that.
The analysis of the content, and we see from the report itself determining which of the submissions are valid or not.
If a service provider who is appointed to assist in the clinical
Yes.
or administrative role, in the clinical or administrative role, puts the submissions into various piles. They say here it's a pile of submissions that appears to be duplicate. This one is a pile of submissions that are improper because they don't made. These submissions are simply
It's just a matter of so in collecting missions and say
Be only in favor that's all they see you in the
my Lord, I refer you to the report itself. It says my Lord, referring to the provided and analyze the submissions and to produce terms
the applicant deals with this notion of duplicates as it appears in the report.
yes.
As it appears